Welcome to Estate Planning with Bernard Law.
Welcome to Estate Planning with Bernard Law and attorney Daniel R. Bernard, founder of Bernard Law PC, serving clients across Long Island. Dan focuses on creating customized estate plans to protect your assets, minimize taxes, and ensure everything is handled as you intend. I'm LeAnn Lyon, and today we are talking about when you should update your estate plan in New York and what actually triggers the need for that change. Hi, Dan.
Hello again. Thanks for having me back.
It's great to see you again. And first question, I guess, is, we had a little conversation before we started this, and I'm excited to talk about those things. But first things first, why isn't an estate plan something that you can create once and leave in place?
Because our lives change, things change, and circumstances change, and the laws sometimes change too. So, what we tell people with estate planning is it's kind of like getting oil changed. They tell you every 3,000 miles. No one listens to that. Maybe no one listens to that. I don't know, but I'm not. But we say every 5 years, or when you hit a major life event, you should take a look at this stuff.
What would be those life events? What kind of changes in someone's life tend to trigger that need for an update or a look at the estate plan?
So there's positive ones. There's getting married, there's having children, having grandchildren can affect your estate plan. Maybe if you start a business, that we would want to do some estate planning around the continuation of your business after you pass away. Then there's the negative ones. If you get divorced, or if your parents pass away and you come into a big inheritance, or if maybe based on their estate planning, they've set up trusts for you. Maybe you need to do your own estate planning to deal with those trusts. So I would say those are usually the big ones: marriage, divorce, having children.
Okay. And how do major family changes, you said, marriage, divorce, having children, affect whether a plan will still work as originally intended?
Sure. So I'll start with the negative. So getting divorced, we have a statute in New York State that says if you divorce your spouse, any beneficiary designations you've made for that spouse, any appointments of that spouse as a fiduciary, so if you've appointed them as your executor, your healthcare proxy, agent under a power of attorney, all of that automatically revoked. If you've designated anything to a former spouse in your will, automatically revoked. Your will is basically probated as if that former spouse had already passed away before you. So they just skip to the next person. They pretend like that spouse died, essentially. The problem is, so a lot of people will say after a divorce, well, I just spent a lot of time and a lot of money with an attorney that usually wears nicer suits than I wear as a matrimonial attorneys. They're real slick, right? I spent a lot of money, a lot of time with those guys, and I don't really want to spend any more time with an attorney. And he told me, the statute is everything's revoked. The problem is revokes for your spouse, does not revoke for your spouse's family, does not revoke for, so if you have your brother-in-law as your healthcare agent, which I see quite often, maybe he wanted to make those medical decisions for you when you were married to his sister. I don't know if I want to making my medical decisions when I'm not married to his sister, right? That's not automatically revoked. I've had this come up where maybe you've left assets to your former spouse's family. They're still going to get those assets if you don't update. So those are the kinds of things I say after a divorce. Let the dust settle for a little bit. Don't wait too long, but let the dust settle. Then come see a nice, friendly estate attorney, and let's just have them take a look at your plan and make sure it doesn't need to be updated for those things. And then the positives, right? People, you get married, you have kids. If you're married in New York State, your spouse can elect against your estate. They can take 1/3 of the estate. But that may not be what you want. You may want them to have 100% of your estate. So if you have an estate plan that maybe you did when you were young, that your parents just told you, if some clients, they get their young kids to do the estate planning when they're doing their planning, that just, if you have a will that says everything's going back to your parents, that's not going to be revoked just because you got married. And we want to make sure that new spouse is getting your assets under your will. Maybe we want to make sure your new spouse is making those medical decisions for you rather than who you've already designated under that healthcare proxy. And we want to make sure besides the estate planning documents, make sure you update your beneficiaries. Your 401k makes sense. Mom and dad as your beneficiary of your 401k when you're 22 and you start that job right out of college if you're lucky, right? But it doesn't make sense when you're 37 and you're married and 2 kids. Mom and dad don't need to be the beneficiaries of the 401k. So we want to update stuff like that. And if you have young kids, you want to make sure your estate plan is going to take care of those young kids. What happens if, God forbid, you and your spouse pass away? Who's the guardian for those kids? And what happens with all the money for those kids? I'm sure you don't want those minor children to inherit maybe your $1 million, $2 million life insurance policy at 7 years old, or maybe even at 17 years old, right? So we want to build stuff into our plan to protect our children from their own youth and inexperience and guard against, bad things happening to us. What I like to say is I'm in the God forbid business. God forbid this happens. We want to make sure we have something in our estate plan that can take care of it.
As a former teacher, I learned that the frontal lobe of our brains, the one that makes the decisions, the logical decisions, isn't fully developed until our even late 20s. So when I developed my estate plan for my children when they were children, I definitely took that into account.
That's the other thing I tell people. It's doing an estate plan is like when you buy a snowblower. You buy a snowblower, it doesn't snow that winter. Maybe not where you're from, LeAnn, but in New York doesn't snow every winter here. My parents got me a sled for Christmas when I was 12. I don't think it snowed again until I was 27. So I tell people, you do an estate plan, you're gonna live forever. But to your point about the frontal lobe, a lot of times people will tell me, 18, my kid's gonna have everything at 18. And I tell them, do you remember what you were like at 18? If I had $1 million at 18, I would not have $1 million at 40. I probably wouldn't have had $1 million at 20. So it's just, so we want to protect our kids from themselves, and we can put stuff in there that maybe we space out those distributions. Maybe we say, hey, at 25, when that frontal lobe is supposed to have come in, will they have some of the assets? But in case it hasn't come in yet, we're going to give you the rest at 30 when scientifically it should definitely be in by then. So those are the kind of things that we can, to your point, definitely plan for. And I will say, I haven't done one estate plan where anyone has told me their kids can get the money at a younger age. Every estate plan I've done, if I tell them, okay, well, last time you were here, we said at 25 your kids can get the money. Every single time it's, what? 25? No way. We got to make it older. So it's just my experience, but that's what I've been seeing.
How do changes in assets like buying or selling properties, growing investments, or starting a business impact the effectiveness of an existing plan?
Sure. So to me, the biggest thing there would be the probate, and we want to avoid probate. And if you've been listening to my podcast, you've been watching these other videos, I talk about that a lot. We want to avoid the probate process. So everything you just described, buying a house, starting a business, those are adding probate assets to our estate. And when we're adding probate assets, we want to make sure those probate assets are turned into non-probate assets. And the only way to turn those probate assets into non-probate assets is to put them into some sort of trust, whether that be revocable or irrevocable. But if you're starting a business, we want to make sure that if you pass away, your spouse can close out that business or sell it quickly, not waiting for a court to appoint them as executor 6 months from now, and then they can sell your business. Then they can pay your employees. We want to have that business continuity. If you're buying another house, we want to make sure that your house isn't going to cause a probate for your kids, and that they can sell your house as soon as they have that ready, willing, able buyer, usually in this market in a couple months, rather than waiting 8 months to be able to close when the court allows them to. So sometimes people may come in their early 30s or in their 20s, and it's just they don't own a house, they don't have probate assets yet, they didn't set up a trust. But once they start getting, then they buy a house, have a probate asset. Now you need a trust. Now your estate plan needs that update to remain effective.
Another thing that I've seen people say is, well, I have the estate plan, it's good, but in New York law, if law or tax rules change, can that outdate an estate plan?
Absolutely. I've been an attorney since 2013, and New York state laws have changed multiple times since then. We've had the estate tax exemptions go up. We had the federal tax laws change. when I first started doing this, there was a lot more people that were going to be subject to estate tax. Those exemptions have gone incredibly high right now. That being said, we're going to have a very big generation of people that are going to be passing away in the coming decades. And what is that going to do to states and the federal finances? The states' laws certainly can change again, especially when the federal government in New York State and the other states see how much money they could be collecting from estate tax from people. And that may be something that they look into. I'm not trying to be negative and project that onto people, but if you go the other way too, right? And that's certainly what I've been seeing so far is the exemptions have only gone up. We've seen people that when I first started doing this needed to do estate tax planning, don't need to do any estate tax planning now. So you may have an estate plan that has some estate tax planning in there that isn't really necessary anymore, and we can simplify things for your family. So that's the laws can change positive or negative effects to your estate plan. And it's also important because you may come in and you don't have a taxable estate, but you may be on the cusp and a few good years of investments. Now you have a taxable estate and your kids are paying some estate tax when we could have done some real simple estate tax planning and saved your kids thousands of dollars.
What are some of the warning signs that an estate plan no longer reflects someone's current situation?
So I would say some of these estate plans I've seen that when the paper starting to get yellow, I'm a little concerned. This might have been around for a while, right? But if you look at your estate plan and you say, "Well, I have 3 kids, and this estate plan only talks about 2 kids," or you look at your estate plan and you say, "Well, my executor was my uncle. He died 20 years ago. I need to move different people into these fiduciary roles," because what I tell people when they're picking their executors, picking their healthcare proxies, we want to pick the best person for today. A lot of times people are thinking, well, who's going to be around when I'm 80? It would be my cousin, but he's a mess right now. He couldn't be my healthcare agent today. You're right, he couldn't. So let's pick the best person for today. And then you can always update these documents as time goes by. And you can always have as many backups in these documents as you feel comfortable with. And I always encourage my clients, the more backups we put in these documents, the stronger they're going to be, the less need for an update because we have those contemporaries in place, maybe behind the people that make sense now, so that God forbid, like I told you, I'm in the God forbid business. God forbid we don't get an update here. At least we may have someone appointed to make things go a little smoother.
Can you walk through an example where someone waited too long to update their plan and it caused problems?
So a recent one within the last few years, I had a client that did their estate planning probably 30 years ago. And now, got some bad health news, made an appointment for me to update the estate plan, and then had to cancel the appointment, and then unfortunately passed away a few weeks later before we were able to meet and update the plan. So then a few months go by. So now, rather than me doing estate planning for this person, I ended up having to do probate for this person. Whereas had I done the estate planning, we wouldn't have had to do probate at all, and we wouldn't have had to spend that money, the court costs, the attorney's fees on the probate. And this, sometimes we can have a taxable estate, and we didn't have, the best tax planning we can do is often before you pass away. So we missed out on doing some estate tax planning, before this client passed away, which could have been beneficial for the family moving forward. So it's, that's a monetary one where we saw, hey, this didn't go the way I wanted it to go. I have another example. I had a client come in. She was very happy because her former spouse had just passed away and everything in the will was going to her. But unfortunately, he had not updated that estate plan. So although, and I believe this, he would have wanted everything to still go to her. It was not they weren't getting divorced for no love lost between them, but he did not update that estate plan to ensure that the assets still went to her before he passed away. And the estate plan did not, I don't think his estate went the way he would have wanted it to go because he waited on making that update.
Well, as soon as we wrap up here, I'm going to go make sure the color of the pages of my trust. Oh, wait. But while I look through it, what are some of the key things as we wrap up here that people should be looking at? What should be reviewed or updated to make sure that a plan is actually current and effective?
So number one thing I would look at is my fiduciaries. Who have I picked as my executor? Who have I picked as my healthcare agent? Who have I picked as my agent under my power of attorney? Because oftentimes as time goes by, it's not the people we would have wanted. It's typically our spouse first. That's okay. Usually our backups are not the people we want. Very rarely am I updating people's estate plans and using the same fiduciaries. The other thing you want to look at is make sure, does this have all my kids in it? Make sure, is this covering all my assets? Is this really how I want things to go? And then the biggest thing is, a lot of times I tell people when they're doing the planning, when they have younger kids, even, teenagers, I tell them this isn't going to be your last estate plan, because at some point you're going to update this and bring your children into these fiduciary roles. So that to me is, maybe if you haven't thought about updating your estate plan, think about, well, when's the last time I did this? And well, how old are my kids now? When I first did this, I was thinking, who's their guardian? Now I'm thinking they can be my healthcare agent. They can be my executor, and I don't need people to take care of them necessarily. Now they're at that age where they can take on those roles. And frankly, they're going to want to take on those roles. They don't want your old estate plan where their aunt is making the decisions and lording over them at 40 years old. They want to be your executor. They want to handle this stuff.
And you just lit another fire under me. Thanks a lot. Well, that is it for today's episode. I have to go. And no, that is it for today's episode of Estate Planning with Bernard Law. If you'd like to learn more about Daniel Bernard and how to keep your estate plan current and aligned with your goals, visit BernardEstatePlan.com. Thanks for listening. And don't forget to leave a review, and subscribe to the show so you catch every episode. Thank you, Dan.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.